Hi, my name is Brian Sullivan. I'm a corporate transactional attorney with the Raleigh law firm of Wyrick, Robbins, Yates & Ponton. I represent small businesses in negotiating commercial contracts, and today's topic for this lecture is basics of contracts for artists. The goal of today's presentation is to provide you with a basic understanding of the key terms that you might see in any contract and how those affect you. After this presentation, my hope is that you'll be able to pick up any contract that you receive and identify the key terms, how they affect you, and what terms might be missing from the contract. In short, I'd like to help you get to the core of your contract, and as such, I'll be using that acronym to guide us in our review of contracts today. So what is a contract? A contract is essentially a legally enforceable promise. In the most typical and basic sense, someone agrees to provide services in exchange for compensation, whether monetary or otherwise. Each of us enter into contracts on a daily basis, most of the times without even paying attention to it. Contracts are important because they document the key terms of the agreements of the parties to any transaction. So what are the key terms of a contract you should be looking out for? Well, let's revisit that acronym CORE, C-O-R-E. The first letter there is C, and that stands for consideration. Consideration is essentially what each party is giving up and receiving in the transaction. When looking at the consideration terms in a contract, you should be thinking about the form of consideration. Is it monetary or otherwise? How much consideration? When will the consideration be paid? And are there any conditions that must be met before the consideration is paid? It's important that these key details be laid out in the contract so that all the parties know what needs to occur in order for the consideration to be paid, and what form it will be paid in, and when it'll be paid. So the second letter in our acronym CORE is O, which stands for ownership. Nearly every contract that you'll enter into will include provisions related to the ownership of the work product and intellectual property that's being produced as a result of the transaction. It's important that your contracts spell out which parties have ownership and use rights in the work product that's being produced. Things that you should consider when looking at the ownership provisions are: which party has the right to use them? Do they have the right to change or modify the work product? How long the rights might last, and whether the rights might return to the person who produced the work at the end of the term of the contract. All of those things are important aspects of ownership that are usually set forth in a contract, and you should be looking out for anytime you review a contract. So the third letter in our acronym is R, which stands for risk and responsibility. Nearly every contract you'll enter into contains provisions allocating risk amongst the parties to the agreement. You can think of this in terms of real-world examples, such as someone getting sick and not showing up for a job, someone getting injured on a job, or someone causing damage to property during the installation or removal of a project. In reviewing a contract, you need to make sure that the risk for these types of events is properly allocated amongst the parties, such that the parties who should be responsible for bearing that risk do so, and that the potential exposure related to those risks is consistent with the contract, the nature of the contract, and the type of risks that might be associated with the project. Some key words that you might look for in reviewing these types of provisions are damages, liability, indemnification, insurance, limitations on liability. And the final letter in our acronym is E, for enforceability. If you're going to go through the effort of entering into a contract and spelling out the terms of your agreement with a counterparty, it's important that you follow all of the formalities required to produce an enforceable contract. In general, that means having a fully completed contract that's dated and signed by all the parties. You should keep a fully executed copy of the contract in your records. This will save you a lot of headaches if any problems arise in the future related to the agreement. So that brings us to the end of our acronym CORE, C-O-R-E. Consideration, ownership, risk and responsibility, and enforceability. I hope that the next time you pick up a contract, you'll remember to get to the core of the agreement and think of this acronym as you analyze the key terms of the agreement.